Hi, good afternoon, everybody. This is just to confirm that you're in the right place for the legal policy webinar for research support and admin staff. I'm waiting for everybody. This is just to confirm. Sorry, that was a reverb of the YouTube. I am waiting for the final speakers to join us, and I also see quite a lot of people still joining. So we'll aim to start at 2 p.m. sharp. Okay, so all of our speakers have arrived. Maybe you can all just do a very quick microphone check so that I know that everything is set. Jacques, maybe you can start.
Sorry, I couldn't hear that first part.
No, just a quick microphone check, so it works.
Yeah, well, looks like it works. There we go.
Okay, so Marina?
Yes, hello.
Okay, perfect. Prodromus, can you check as well?
Yes, hello.
Okay, check, good. And Thomas?
Can you hear me?
Perfect. Okay, that means we're all set.
When just quick. So I just sent you an email with my slides, the updated ones. You saw that because this morning my connection or I don't know, Zoom or something had wasn't super fast. So just in case it does it again, then you share your screen showing my slides. Is that all right?
I will do that. Don't worry.
Thank you.
Okay. Okay, so hi again, everybody. This is just to confirm that you're in the right place for the OpenAIRE Legal Policy webinar. I see many people are joining right now, so I'm just going to wait for 1 more minute, and then we'll start. Okay, let's start. So good afternoon, everybody, and welcome to this second edition of the OpenAIRE Legal Policy webinars. We had a first one last week, which was mainly aimed at researchers. This one is mainly aimed at research admin and support staff. But of course, these webinars are open for everybody. So if you're a researcher or if you have another function, you're more than welcome. I would like, before we start, I would like to have a couple of short housekeeping announcements. So the first is that the webinar will last for approximately 75 minutes, including Q&A. Of course, this depends a bit on how many questions are asked, but we'll aim to be ready after 75 minutes. If you are a participant, you are standardly muted, and it is not possible to share your video. This is because we don't want to, we want to ensure a smooth webinar for everybody. If you have a question for the presenter during the webinar, please use the Q&A box. You should see it if you hover with your mouse over the bottom of the screen. You see a Q&A. You can just simply enter your question there. You're a lot of people, a lot of participants, so please try to be precise and complete in your question and try to keep it to one question per entry and indicate to whom your question is. This will facilitate the Q&A. If you have any technical questions about the infrastructure, if you want to say hello or goodbye, please use the chat. We will not record the chat. So please use, if you have a question that is pertinent for the contents of the webinar, please use the Q&A box. Some of you send in questions in advance, and these have already mostly been incorporated in the presentations. If you don't have an answer to your question by the end of this webinar, please just use the Q&A and we'll try to deal with it in any case. So the webinar is recorded, and the slides will be shared via the web page that is here via OpenAIRE site. You will see that there are already recordings and slides there from last week's webinar. We will add recordings and slides from this week's webinar on the same page. Please note that because we had so many registrations, you will not receive an additional email for this. So just check back that page at the latest tomorrow. You will have the recordings and the slides ready there. This webinar is also being live streamed on the OpenAIRE YouTube channel. So if you just go to, if you have issues connecting with Zoom, or if you have any colleagues who don't want to enter Zoom, you can just go to the channel and watch it there live. And we also have a short satisfaction survey for which we will be very grateful if you could enter this afterwards. I have two more short remarks that are not on the slides, but they're related to some questions that we received during registration. So the first of all is there are quite some people asking questions about the how and why of data management in Horizon 2020. So just so we're clear, this webinar is not going to be about data management planning as such, nor is it about Horizon 2020 open science policies and open data sharing policies. We do have already some webinars on that subject as well. So if that's your main focus of interest, please just check the OpenAIRE YouTube channel and you will find what you need there. And we're also regularly repeating our general information webinars on that subject. So don't worry, you're more than welcome to attend this, but we will not be dealing with that subject per se in this webinar. What we will be dealing with is, of course, this is the agenda. So first we have Marina Angelaki, who will introduce very shortly OpenAIRE and point you to some the activities of the Legal Policy Working Group and to some interesting resources and guidelines that you can find on our portal. Then we have Thomas Margoni, who will talk about data ownership and open science. Then we have Prodromos Tiavos, who will talk about research data and the GDPR. And then we have Jacques Flores, who will elaborate a bit further on the practical consequences and examples on how GDPR influences your data sharing. We will keep the Q&A for the end, at the end, but the presenters will keep an eye on the Q&A during their talks as well. So as experience showed last week, they will manage to answer some of the questions already as they speak. So then there's nothing else left for me but to wish you a very fruitful webinar. If you have any questions afterwards, you can just email us at webinars@openaire.eu. Also, if you have additional questions for the presenters, you can reach us there and we will pass your questions on. So Marina, I would suggest that you start right now. I'll stop sharing my screen.
Okay, let me just share my screen. Okay, so good afternoon, everyone, and thank you for your interest in our webinar. Before proceeding to the presentations, as Gwen said, I would like to give a short introduction on what OpenAIRE is, what we do, and the different ways in which we can support you. OpenAIRE started in 2008. At that time, it aimed mainly at supporting the open access pilot in FP7. Currently, we have a much wider vision and mission, which is to shift the scholarly communication towards openness and transparency, and to facilitate innovative ways to communicate and monitor research. While doing so, we work with a variety of stakeholders like policymakers, content providers, research support staff, IT experts, legal experts as well, and obviously researchers, and we provide a variety of services and tools to support all these stakeholders in their work. So what we support, first of all, we support the development and the adoption of open science policies. We support policymakers and institutions and funders in developing and aligning their policies with the European framework, and we have developed a number of templates and fact sheets to support you in this work. We also provide interoperability services that connect research and enable researchers, content providers, funders, and research administrators to adopt open science. We help you in enriching your metadata, and also we provide statistics for repository access, and at the same time we help researchers to funders, to monitor the outputs of the research they fund. We also support researchers with their research data in complying with the FAIR principles. We have also developed services such as Amnesia to help you in anonymizing sensitive data, and also the Argos tool to support automated processes to creating, managing, and sharing data management plans. And obviously, we also support you in providing open access to your publication through the development of different guides by helping you to choose a repository that better suits your needs. How do we support you also in more practical ways? We have a help desk where you can ask us questions related to open access and open science issues, whether this has to do with compliance with the Horizon framework, or more specific issues such as legal aspects, such as the ones that we will be discussing today. We have also developed FAQs where you can find answers in different and over the years, we have also developed a variety of resources, such as I mentioned before, guides, templates to facilitate institutions and funders in adopting open science policies, fact sheets dealing with issues such as, for example, copyright issues. And also we provide, we have developed an extensive program of training, physical meetings and workshops where you're all invited to participate, and webinars focusing again on different aspects, not just those that are related to compliance with the Horizon mandate, but also tackling other aspects of open science, such as, for example, citizen science or open innovation. A key element and a very important aspect of OpenAIRE is the network of the national open access desks, usually referred to as NOADs. It's a pan-European network covering 34 countries. And its creation lies in the fact that while research is global, support is local. We have all come to realize that obviously this support needs to be tailored and take into consideration the differences between countries, and also the different levels of maturity in terms of the infrastructure that exists in each country, whether they have already they already have policies or they might not have, the level of awareness in terms of open science and its different aspects. This means that there is no one-size-fits-all approach, and therefore this network of national open access desks is there to help all of you, whether you're a researcher, a policymaker, or a content provider, and guide you in locating the different resources and having the appropriate support. As Gwen mentioned in the beginning, we have developed a number of different guides that and resources that are available on the OpenAIRE portal. We encourage you to visit our portal and browse through the different materials and resources that are available. And as I mentioned before, they focus on different aspects, not just how to comply with the Horizon, for example, mandate, but also with legal aspects, providing support in locating trustworthy repositories for your data or your publications, for example. Finally, we organize a number of webinars. They're free to join. The recordings are also available on our portal. So again, we encourage you to visit the OpenAIRE website and browse through the materials that we have developed over the years. So I will now present our three speakers. The first one is Thomas Margoni, who is a senior lecturer in intellectual property and internet law, and co-director of CREATE at the School of Law at the University of Glasgow, where he also convenes the LLM program in intellectual property and digital economy. Thomas' research focuses on the relationship between law and the new technologies, with a particular attention to the role of the internet as the new medium to access, create, and disseminate knowledge in the information society. Our second speaker is Prodromos Tsiavos, who is the head of the digital development at the Onassis Cultural Center in Athens, and he's also a senior research fellow at the Media Institute in London. Currently, Prodromos is advising Athena Research Center on legal and ethical aspects of data science, and is teaching legal and ethical aspects of data science at the Athens University of Economics and Business. Prodromos, Thomas, and myself are also coordinating the policy and legal task force. And finally, Jacques Flores, who is our third speaker, is an information and research data management specialist in at the Utrecht University. He comes from a neuroscience research background, and his role is to support researchers and students throughout the various stages of the research flow, from data collection to storage, management, and analysis, to data sharing and accessibility. He's also a certified information privacy professional, which allows him to help researchers who handle personal data as part of their research. So I will now give the floor to Thomas.
Thank you very much, Marina. So I cannot share my screen yet. I need to be made, or you're still sharing your screen, Marina?
I'm still sharing my screen. I think that now I've stopped sharing my screen. So, yeah.
Thank you very much.
Yeah.
Let me see if this is the right one. Yeah, perfect. So good afternoon, everyone. Thank you very much to Marina and Gwen for the nice introduction, the kind words, and especially for their effort to organize these two webinars on policy and legal aspects which have proved to be so far very popular. So another thank you to everyone who is dedicating us their time to follow this discussion, which revolves around topics that that are complicated and that are especially for researchers, something that it's not their main focus. They do research how to deal with the data or results of their activity from a legal point of view is something that should be as seamless as possible for them. So I think that today's webinar is especially important because the idea is that together, so through our presentation and through hopefully the new knowledge or the better understanding that many of you as a professional who work in the research administration framework, we will all together be able to make the life of researchers, if not easier, at least a bit more understandable from a corporate point of view. Today, my presentation will be very similar to the one I gave in my previous webinar. I have mildly adjusted it in the light of some of the feedback. So I will try to be less technical if I can. I'll probably go a bit faster on some of the more technical topics, and I collected the questions that some of you sent in before the webinar, and I tried to offer some answers. So maybe I'll try to focus more on these last 2-3 slides. And obviously, if there are more questions, I'm very happy to take them on the live chat or at the end of the 3 presentations. So my focus today is on the ownership side of data, and as such, the legal area that is mostly affected by this situation, it's that of copyright, broadly understood. And the main question that often causes a lot of confusion is whether data is owned. And we all often hear about this is my data, or well, my PI said that the data I collected is his, or want to move to a different university, or I got a job, can I take my data with me? So obviously these are very intricate questions, but hopefully we'll try to make some clarity. And I think that the most important point here is to understand that copyright as such says that data cannot be owned. Ideas, procedures, methods of operation, mathematical concepts, etc., are not protected by copyright. All national and international conventions are very clear on that. Only original expressions are protected. So the example is that if you want to write a tale about a doctor who goes crazy and wants to create a monster made of pieces of other humans, and then the monster turns out more crazy than the doctor, and then there is I don't know, an ironic view on the role of humanity in modern times, then you can do that. What you cannot do is to copy the original expression by Mary Shelley. So under this point of view, we can easily say that factual information and data as such, and the as such is very important, fail to qualify for copyright protection precisely for this reason. Now, this doesn't mean that there is no whatsoever legal protection for data. We can find other areas of law that offer, to a certain degree, protection for data. But it's not a fully fledged, let's say, property right, so a very strong right as it would have been in the case of copyright. Here we have trade secrets, much more common in the private sector rather than in universities, but they exist also in public research. contracts, data protection, as we will see later today, PSI, etc., etc. The main message here is that this tool can offer some limited protection, but you cannot really talk about data ownership usually under these tools, or not completely. What about databases? Because this, at least from a legal point of view, is a completely different categorization. The law says that databases are protected by copyright if the selection or arrangement is original. But in this case, what is protected is the original element. So only the selection and arrangement, we could say the structure of the database, not the contained data. So for example, if we had an original database composed of copyright protected elements, let's say journal articles, then we would have a protected structure, and then the elements of this database would also be protected, but not because they are data from a legal point of view, but because they are work of authorship, they are journal articles. If the contents of this database were, let's say, non-protected data, such as temperature measurements, then we would have a copyright in the database structure, which, however, does not extend to the content of the database. So these measurements could be easily reused by anyone, because this data as such is not protected. Now, in Europe, this is more or less, with a good degree of, with some approximation, but not too much, the situation worldwide. In Europe, there is an additional layer, a form of protection for non-original databases, which extends to data in certain cases. So in this situation, we still need a database, so a methodological organization of elements that are individually accessible. But we're not looking at the structure anymore. We're looking at whether there has been a substantial investment in obtaining, verifying, or presenting the data, not in creating the data. And that obviously opens a huge door in terms of what data are created and which one are obtained. In this case, the substantial amount of the data, so not a single datum, but a substantial amount, again, how to quantify it's another big question, is protected by the SGDR or sui generis database right. Think of a lighter form of copyright. This means that we could have up to 3 different layers of rights protecting a database. So the copyright in the structure, the copyright in the single elements if they are protected by copyright, and this SGDR in the substantial investments that protect de facto a substantial amount of data. So it's very important because it also means that if you want to reuse that database, you need to ensure that you have an authorization that covers all these 3 layers. And if you are the author of that database, then it means that you need to choose the right license, so a license that will cover all 3 layers. And in this case, a CC BY 4.0, it's a very good choice. There is another category of data, so those data that are not contained in a database, but in a work. So the example here that most applies to maybe natural language processing, machine learning, etc., is whether you can extract statistical information, say about the English language, from a Harry Potter novel. So in theory, the answer would be yes, because this information is not protected as such. But in practice, because how especially EU law is framed, and I will avoid to enter into the details here, no, you need an authorization. And this authorization can take the form of a TDM exception, for example. So this is a statutory authorization, let's say, or a contractual authorization, let's say a license. So we are in a weird situation because, modern data analytics rely heavily on extracting these unprotected elements from protected works. So under this point of view, we can reach the conclusion that even though there is no such a thing as ownership in data as such, we're in a situation where, because of how copywriting works and the sui generis database writing databases work, very often you need some sort of authorization, either license or exception. Even though, as we say, data as such is not owned or protected, which, as you can imagine, it's the source of all your headaches when you receive this question and you don't know how to answer. It's also useful to keep in mind that this extremely complicated situation is peculiar of the EU, whereas abroad, in the States, but also Canada, Singapore, Japan, you name it, not every country, but a growing number of countries, this has been solved on a much more, sometimes I say pro-innovation way. And obviously this leaves the EU research and innovation sectors at a disadvantage if compared with these other countries. So is data owned, and why does it matter for open science? I think that this is a very important aspect that should be made clear, especially when you talk to researchers who say, well, I spent the last 3 years collecting this data. How can you say they are not mine? So the goal of the law here, it's by excluding protection of ideas, principles, factual information, non-original expression, etc., is to avoid the creation of monopolies over the information needed by everyone to think, communicate, and create new knowledge. And this is very important for not only for scientific freedoms, but for us as a society in general. So for the basic fundamental rights to freedom of communication, freedom to impart and receive communication, freedom of scientific inquiry, etc., etc. And similarly, by excluding in databases the created data element, the goal of the law is to avoid a single source databases, because this would create very anti-competitive situations. So the idea behind the theory of the law would be that on the one hand, these basic bricks of human knowledge, ideas and data as such, are not owned, because everyone should have access to them in order to reuse them, verify them, replicate them, because it shouldn't be a peculiarity of open science, verifiability and replicability. It should be what determines whether something is scientific or not. If something is not verified, characteristic, it has to be reusable, then it's simply not scientific. And in many fields of science, the opposite approach has caused in terms of replicability. On the other hand, the law recognizes that there is an investment that people make in collecting this data, and they offer a limited reward to compensate for this investment. And this limited reward is or should be, if the copyright law followed copyright theory, would be framed around the distinction between creating and obtaining data. So this is why it's so important and why it's matter for open science. Now here I brought an example that I will not discuss in detail, but is the text and data mining exception, how it works in the UK and in Europe. So the reference to the CDPA is the Copyright Design Patent Act UK, and the CDSM is the Copyright in the Digital Single Market Directive, the EU directive. And you see how many limitations the text and data mining exception has to follow. So if we were in, say again, the States, the only word in this slide would be, can I text and data mine? Yes. You see how different is the approach, and you can imagine the implication for research and innovation. So here I have a list of the guides. We don't have to go through them, but I think they are very important. And I really would like to ask you to please follow them, look at them, read them, and tell us, if they are useful, how useful they are, if there is anything that we do not cover, what do you need in addition? Because for us, it's extremely important to know what you do not know, because I know well, not all of the answer, but I know many of the answers. So for me, in order to create a guide that covers something else, I need to know what you don't know. And, the same is true for prodromus, I'm sure. So please give us feedback. That's very important. Again, I have a couple of minutes left. So this is a list of recent initiatives connected to the COVID pandemic. Again, open access is not recent, but is the best approach, because it means that you do not have to ask for permission on every single occasion. You have a general public license, thus a general public permission. And there are many initiatives that try to push for a similar approach, at least in connection with the current pandemic. Again, you have the links, you have the recording of the previous seminar if you want a discussion that enters a bit more in the details of these initiatives. And here I'll try to go through very quickly. On my watch, I have 1 minute and 30 seconds left. So sorry if I am a bit fast, but I think it makes sense to go through some of the questions we collected. How can I guarantee the use of data? The short answer is apply a CC0, because we said that data as such are not protected. With a CC0, you make sure that even if there is some form of protection, let's say a sui generis database right, you waive those rights. Now the long question, the long answer, you find it in the guides, and it depends a little bit on that situation that I described in the case of databases, where we have up to 3 different layers. So, the short answer is CC0 is probably the best license for data, because it's not a license, it's just a waiver of any eventual right that could exist. Otherwise, please consult the guides. The Open Data Directive and the IPR may conflict. They may, but it really depends on a number of factors. In the simplest scenario, open data requires reusability, but accessibility is a matter of national law. Also, the PSI, the Open Data Directive, makes save IP rights that belong to third parties. So that's another, area of exemption. Again, it also depends how this reusability is framed under national guidelines, laws, or regulation, because if there is a right, then that right probably it's licensed following either a CC license or an open government license. And in that case, the third party who would like to reuse that data has to follow the license. Again, it depends what kind of rights exist in that data. So this brings us back to the first question. I won't enter into the details, but there is a situation where there is a license that is applied to data which are not protected, and what is the value of that license. If you want to know the answer, please ask me. If you don't know what I'm saying, please discard completely this issue, because it's interesting, maybe more from the academic point of view. How and under which umbrella can data legally be protected? So hopefully this is clearer now. Data as such is not protected by copyright or the sui generis database right. Data structured in a database may be protected by the GDR if there is substantial investment in obtaining, verifying, or presenting but not creating. Trade secrets may protect data as such, so there's no need for a database, but only under certain conditions. Contracts may do that as well, but only between parties to that contract. How can information be retrieved without being considered a plagiarism? Well, the general answer is ideas and facts are not protected, so you can reuse them. Original expressions are, so do not copy original expressions. This is the answer from the legal point of view. But the law doesn't cover all aspects of our life. So there are also norms that apply in a certain community. So in the scientific community, even if you copy the, say, I don't know, a novel idea by a colleague without really infringing on his copyright, the scientific norm, which comes with some sort of social remedies, is to acknowledge that idea. So you're discussing a new idea that you heard at a conference, and you say, well, you know, thank you to Professor X and Y for inspiring me this idea. Is it legal to summarize my thesis in an article that may be published in the international journal? Well, if it is your thesis, so the copy belongs to you and you did not transfer to anyone, and there is no, let's say, you know, it's already been public, you defended it, then you can do in principle whatever you want from a copyright point of view. I'm interested in how to make researchers understand that it's important to protect results before publishing results. Many of them are extremely focused on in publishing the results and eventually have some problem when trying to protect them via patent, for example. So in the case of patents, yes, you have to, you know, if you disclose your potentially patentable invention before you file for a patent, then you're the strong novelty. So you could preclude yourself that path. But that applies only to patents, and usually, hopefully, universities have technological transfer offices that are dedicated to advise people, scientists in this area. It's also true that this applies mostly to patents because patents need to be registered, whereas copyright and the sui generis database right operate automatically, so you don't need to register copyright. By the, you know, the expression is the sole fact of creation, you are protected by copyright. So in the case of copyright, this form of protection is more automatic. And then it depends a lot on the strategy of universities. More and more universities are realizing that only certain patents can be properly exploited commercially, but a lot of the information and the knowledge that university generate should not be prepared, you know, exploited through the standard patent route. So, you know, this is perhaps more of a university strategy issue that applies specifically to the patent field. This, I think, is the last question. I hope I didn't rush too much through them, and thank you very much.
Thank you, Thomas. Just before proceeding to our second speaker, just to remind everyone that if you have questions for the presenters, you can use the Q&A window, and for all other questions that are of more general nature, more technical or related to the infrastructure, please use the chat window. So Prodromos, the floor is all yours.
Thank you very much. Just give me a second to share the screen.
Yes.
Right. Okay, it's great to be again here. And as similarly to Thomas, I have adjusted the presentation on the basis of the feedback we have received after last week's presentation. And so I hope it's going to be less technical, though it's inevitable to make reference to certain legal provisions. Again, I'll try to.
Ramos, sorry, I'm interrupting you. You have your vision is in presenting mode, in presenter mode instead of like.
All right, for some reason,
yeah.
1 second. Let me just try. Let's just stop sharing. Perhaps I'll try because I have to monitor. Perhaps for some reason that is the case. Let me try again. Let me know. Oops, sorry. For some reason it doesn't work. Give me a second. All right. One. Try again. No. I don't know why. It's I cannot even see it now. Just give me a second. Let me try again. Is it working now?
I don't think you're sharing right now. Can you try again? Can you actually push the share button?
I did. Does it work now?
No.
Let me try again. For some reason, I get 2 instances. Does it work now?
Yes, yes, yes. Now you are in the normal, like in the editing mode. So if you click at the bottom.
Yeah, I'm just trying.
Yeah.
Is it working now?
Yes.
Okay, and you see the not the speaker's notes, you see the actual thing.
No, it's good now. Yeah.
Right, good, sorry for that. All right, so trying to give at the beginning, the outset of the GDPR, which I think is quite essential to understand why it is important to actually both adhere to GDPR, but also see it as basically a set of instructions rather than an impediment. Some key items about how do we go about when we have a data set which contains personal data, a bit of the setting in relation to what constitutes scientific research, and also defining the scientific research in the context of GDPR. A few things about the purpose processing, the legal basis, and the data subject rights. And then I tried, similarly to Thomas, to collect questions we have received over the past couple of days and try to address them within the context of our presentation. So the first point, which is for me quite important, is to appreciate that the General Data Protection Regulation is mostly a piece of regulation which is about indicating how we are to share our data. It is not just about protecting natural persons from the processing of personal data, but also about the free movement of such data. And this is a very important thing because when we actually have any data sets, we need to be able to actually identify the different range of data that we have to deal with. What is the kind of processing we would like to do? Very, very important. What is the purpose of the processing? And scientific research is a very broad purpose, and we need to be more specific about it because that directly links to the legal basis. And here we need to be particularly careful with the case of sensitive personal data, the special categories of personal data, precisely because they require extra protection and extra care from our side, and this is translated in very specific steps. And of course, making sure that whatever we do in terms of the processing and the purpose we have, it is covered by the legal basis. And I'll return to this one later. The setting with which we work is normally within a research performing organization, and this practically means we need to adhere to 2 sets of rules. The first thing is the General Data Protection Regulation as it is. It has been exercised within our jurisdiction, and that is quite important in relation to particularly the rights of the data subject, and I'll return to this point later. And secondly, in relation to the ethics framework that we have in our research performing organization. The reason why this is so important is that it's very frequent that the ethics framework provides additional obligations. We will say it in quite a few times, but it could be that we could use as a legal basis the public task, but we end up with consent precisely because we need to do so due to the ethics framework we have in our institution. The second thing is the EU or other collaborative projects. And this is a classic question. What happens when I have a collaborative project, let's say a consortium responding to an EU call, and there are some personal data involved? And here, there is, of course, no answer that actually covers all cases, but we would generally suggest that we actually check the work packages and see where exactly the personal data are processed. Are they processed by a single partner, by multiple partners? In the CA and the work packages, the consortium agreement and the work packages would actually let us know about that, would tell us about that. And at the same time, it is important to understand why we are processing this data. So for instance, in almost all European projects, we will have a dissemination package. It will certainly have different databases in relation to people or institutions we would like to contact. When we have this list of people, which are natural persons, we have to make sure we do that in accordance to the General Data Protection Regulation, and here the legal basis is not going to be the scientific research. Here, the legal basis would most probably be legal interest or consent or some other justification we have as to how the data have been obtained. If the data have been obtained by multiple sources, we have to make sure there is a legal basis both for how they have been collected and how they have reached us. The second area where we see a lot of personal data processing is the actual data. And here the purpose is clearly scientific, but we have to see how they have been collected, for instance, directly from the data subject or from a third source, and why are we doing that? In that case, we have to see how we are compliant with ethics and data protection requirements, which again, they have to, at the point of processing in the work packets where the data are being processed. Again, we may have collaborative projects which happen within a single jurisdiction or in multiple jurisdictions, or as we will see at the end, in relation to other institutions and entities in third countries, that is non-EU countries. In those cases, we need to make sure that these institutions have an adequate framework of data protection as we do. That is mostly going to be expressed in the contracts or between these third parties and us. Either when we work as a processor or as a controller, or as co-processor or as co-controllers. In most of the cases, we are going to be operating as co-controllers, and we need to make sure all necessary measures are in place, and they have to be expressed in the contractual agreements. There has been a question as to whether there is model such agreements. Indeed, there are, and we are going to speak about them at the end, but we would always suggest that you get advice from your legal department as to how you form them, because each case is very different. Also, the call may have conditions in relation to developing an ethics report, a data protection impact assessment, or other additional requirements that stem from the call itself for the project. When we have a tender, and it's not a simple call, the tender with the commission, for instance, or a public authority or a private entity which actually asks you to perform some kind of research, then the legal basis is most probably going to be the contract itself. And in all cases, or in most cases, you're going to be operating as a processor or co-controller, but not as a controller. In all these cases, it is important to identify who the data protection officer is and how the data protection officer of your institution interacts with other data protection officers in a consortium or in a tender, in any kind of agreement you have with any kind of contracting authority. Now, in terms of the definitions of scientific research, we find it in multiple places within the General Data Protection Regulations. Most important is Article 89, where we have the definition and operation of the scientific research, but we also find it in several recitals, as well as in the definition of processing, but also in the limitations and exceptions, actually to the exceptions or in relation to the data subject rights. So this is quite important to see where it is irrelevant. Scientific research is relevant as a legal basis, or to tell us things about the legal basis, or it is very relevant in order to understand the range of processing we can do, or finally, how the rights of the data subject may be exercised. Scientific research, what we see in Europe in particular is that this is something which is mostly falls under the broader public interest legal basis. So this is not the only possible legal basis. As I mentioned before, very frequently we would have the case where we have consent as the reason why we are processing personal data, and there could be other legal bases as well, but mostly these are the most frequently found ones. Another thing is that another very frequent thing is that the processing for scientific purposes constitutes itself further processing, or it could lead to further processing. Let me give you two examples. First case, I obtained data from a public source, a public hospital, and then I process them for scientific reasons, or I obtained the data from social media. In both cases, they have been collected by a third party initially for purpose one, and then when I engage into scientific research, I change the purpose and therefore even the legal basis, and we'll talk more about it later. What is essential is in all these cases that the appropriate safeguards are there. So it is it remains a fact that the General Data Protection Regulation provides you with a pretty good basis for processing personal data, but you still have to put appropriate safeguards in place. And this would normally be of two kinds: data minimization, which means you only use the data you need. For instance, if you are processing a child's personal data because you're doing research which involves children, it's not necessary that you keep the name, even if it could be that you keep their image, or you don't get their address unless you need it for other reasons, for instance, for contacting their parents. In all cases, also, it is wrongly suggested that the data are pseudonymized, at least, if not anonymized. And this is a necessary, let's say, condition for processing them, unless, as we'll see later, this interferes with the research itself. Now, when we have special categories of data, which means what we used to call sensitive data, you will see that we have a repetition of some of the key principles of personal data protection, especially proportionality, respect of the rights to data protection, and also providing, again, suitable and specific measures to safeguard fundamental rights. And these suitable measures, again, they would pretty much have to do on the one hand with minimization and pseudonymization, but also with how the data subject is able to exercise her rights. So it's very important if, for instance, I process, let's say, sensitive health data, I have to make sure that all necessary notices are there. I have to make sure that if the data subject wants to object, they have the possibility to do so. And I have to make sure that I have in place organizational and technical measures to prevent any kind of leakage of the relevant data. Now, in terms of the purpose itself, we have, as we said, the overall purpose is always scientific, but specific types of research may require specific types of legal justification and legal basis. And in that sense, we need to see how we link those two. So it could be that I do a secondary use while the original collection has been done by a hospital or by a public authority for statistical reasons. Even if when I stay within the same legal basis in name, for instance, public task, I have to explain how this public task is retained. And I'll return to this question when we talk more about the further processing of data. And we mentioned quite a few, some of the legal basis, public interest, contracts, consent, and how this changed. So let me go give you an example. And here again, you can see the legal basis. If we have, if in order to understand how this legal basis remains, we have to trace the data. We have to follow the data. Using the data management plan as our backbone is a very important yardstick for what we want to do. And we can see how different types of data processing, they may serve different purposes and have different legal bases, but we always have to stay within the legal basis. So for instance, I get the example which I mentioned before. The data collection is taking place because of public interest reasons by a public authority. So this is the data collection stage and this is processing. But we have a researcher who's actually taking these data and updates them, enriches them, improves them in order to perform her research, which is again public interest, but is a different public interest from the original one. So this is a case of further processing. And it could be that this needs to be preserved for, let's say, 5 years after research has taken place for reasons of auditing, which is a legal obligation, or it could be a contractual obligation. And then when the data are to be released, because let's say it wasn't possible or it wasn't relevant for the research to be anonymized or fully anonymized or pseudonymized, then what the researcher does, it obtains a consent. So in all cases, you may have the same data set or slightly different, which changes places as it is being processed. You see there is always a legal basis. Now, we will see how this works at the end in the question section. But before going there, I just would like to finish the main presentation by actually saying that the processing of personal data for scientific purposes is also entailing a severe limiting of data subject rights, which is, however, accompanied by a series of, again, of measures that try to mitigate the damage that the person whose data are being processed, the data subject, is actually occurring. So more specifically, there are limitations in terms of the data subject rights to be informed, but this has to be, it can be done, but then the provision of the research is either, the provision of the information is either impossible or would involve a disproportionate effort, which means, for instance, if I have collected data from a public source and in order to contact all individuals of my data set, this would render it impossible because of cost and time, then it is very likely that I don't have to actually provide such information. And in all cases, I would make sure that this doesn't kill my research, and I should be sure that whatever I do, I try to protect the data subject's interest as much as possible. Secondly, the right to be forgotten can be also limited for the obvious reason that it could be that such right actually stops research. It could be that I need to have, for instance, in the context of historical research, I may need to retain certain pictures. If someone has or exercises the right to be forgotten and this kills the research, then I have the right to object to it. And finally, if the data subject wants us to stop the processing of data because of objection, I can reject that as a researcher for reasons of public interest. Another important thing is always look at your national laws, because there may be national derogations in 4 types of rights: right of access, rectification, restriction of processing, and right to object. So national laws may provide variations in relation to how the data subject may exercise such rights. Now, moving to the questions we have received, I have collected some of them here in questions, and let's try to see each one of them separately. The first question is, what if I reuse data which I have harvested from publicly available resources, sources, or in general, data which have been obtained from different sources? In all cases, I have to check what was the original purpose of the processing. So why were these data obtained in the first place? So if this is, for instance, data found on Facebook or social media, they would have as their legal basis a contractual relationship or consent, depending on the situation. And then I have to check what am I going to do with my processing, this processing. And in order to do, in order to actually be engaged in further processing, I will have to notify the data subject for a range of things, from the identity of the controller and my data protection officer to the purposes of processing, the categories of personal data used, who else is going to get the data, if there is someone outside Europe that is going to get the data, and where it came from. Now, apparently, in these cases of further processing, I have to see to what extent this is something which is feasible. And again, I have to see what is, again, the legal basis under which I am processing the data. As we said before, it always has to be, there always has to be a legal basis. So this legal basis either is the same, or it is consent, or I have to somehow identify a new legal basis. And when I want to further processing without obtaining a fresh consent from the data subject, then I have to check what is the relationship between the previous legal basis and my new legal basis. So if the hospital has obtained the data in order to contain an epidemic, is my new processing compatible to this original process? Or if it has been obtained as a result of a contract, is my research compatible? And the General Data Protection Directive regulation gives us 5 very specific conditions to check that, to see what is the link between original and further processing, what is the context, if there are special categories, what extra measures have I taken, and what are the safeguards which I'm using for processing my data. In all cases, the information of the data subject has to be given, and I should always try to pseudonymize this data. If the data are transferred to a third country, there is a whole, again, range of conditions for doing so. Very important, what is the contractual relationship between us and the third and the entity in the third country? And that's why before I mentioned the contract and also the possible consortium agreements, also if there is a standard contractual clause. And here again, we have some conditions, some sort of contractual clauses by the EU, which I would also suggest for those that want to see one to actually check the SEC clauses. What happens if the initial collection is for legitimate interest and secondary research use? Here, what is important is to have a very solid notification process to the data subject and a very solid objection process, so that it is possible for the data subject to get out of the processing if she wishes to do so. Whenever we have further processing, the obligations of accuracy and minimization clearly decrease. So it means we have to make sure that we follow all the conditions mentioned before, but we also have to make sure we minimize data as much as possible. Health data and GDPR, Jack is going to talk more about this one. Always bear in mind, these are special categories of data, and we have to see how we actually process that data in order to make sure that the purposes is proportional to the legal basis we use. Data sharing codes of conduct. I suggest to check the ICO in the UK. I think this is a very good document to see different data sharing codes of practices, and of course the relevant OECD webpage, which has the ethics codes of conduct list. Someone has asked if there is a personal data for a small project other than Excel. I would say if it's a small research project, Excel rules, unfortunately, but how you fill in and how you construct such Excel document is quite important. And I would make some very simple suggestions. Specify your research purpose and define a data range. Make sure you specify and document your legal basis. If you have consent, make sure you manage it properly. So it means that you provide all necessary information, you store the consent, and make sure it covers all the types of processing and your purposes. As I said before, use data management plan as your backbone, and always consult with your ethics committee and data protection officer. So I try to cover most of the questions in 20 minutes. I don't know whether we are going to address questions now or later.
Let's, Prodromos, there are quite some questions for you in the Q&A. Let's address them after Jacques' talk, if that's okay.
Yeah, that's fine.
You should all now be able to see my screen. Is that correct? Yes. Well, good afternoon, everyone. I'm Jacques Flores. It's already introduced a little bit. But what I want to talk about is an extension of what Prodromos just talked about, right? So I'm still going to be going over the GDPR, but a little bit more on how it applies in research setting, given my experience also within research. So I will go over the legal basis once again. Just from our perspective, we see it similar. So there's quite a few ways in which you can lawfully process personal data. Now we have informed consent and legitimate interest of the controller. Now, normally at our university, we use informed consent as our legal basis. And this is because it also meets the ethical obligations that we have towards our participants. So as you know, even if you use, let's say, public interest as your legal basis, oftentimes you will also require an informed consent because it's also an ethical demand. And as such, this is the road that we take. Now, sometimes we've actually used legitimate interest of the controller. Now, this is a particularly difficult legal basis to define sometimes, but it can be used in certain circumstances. But if you are to use this, you must know very well why you think you're allowed to use this. And in our case, when we do recommend this, sometimes for social media or similar studies, we do demand a data protection impact assessment, which is a very detailed look into whether you can actually process this data and what the risks are to the data subjects. Now, public interest is something that we've considered as using as our legal basis by default. but we're still not entirely certain when something is actually to the public interest entirely. Now, we know that we are a public institution, but does this denote that we are actually, every research that goes on is for the public interest and is necessary for the public interest? Now, we know for certain cases, for example, COVID-19, the European Data Protection Board has already made it certain that if you are doing research and you want to share data concerning this is actually in the public interest. Now, the fact that they make a statement for the COVID-19 still makes us consider maybe in the future we can use this legal basis more freely and not be afraid that perhaps it does not apply to every single research instance. Now, when we are talking about informed consent, there's some things that should also always be there now. So for researchers, since we use this as our main legal basis and as well as our ethical one, we try to make sure that they're making these the right way. Now, of course, they're freely given, specific, and informed. And usually in the informed part is where sometimes we see some things give out. Now, at the end of this presentation, my aim is to give some input on how to make informed consents more suitable for sharing data. Now, an important part of information, and Prodromos already showed this, is some of the information that should be there. So I'm not going to go over this since it's already been presented, but these are things that definitely should be in every single informed consent. And more restrictions apply if you have, say, you're transferring the data to another country. We also looked at purpose limitation. So Prodromos talked about this in further processing. Now, this is quite important for research. So I really wanted to expand on this and show you guys how we use this, how we look into this to make sure that certain research can go ahead more easily. So the GDPR distinguishes between two types of data use. We have the, let's say, the initial data collection use, which is when you use data directly collected for a particular purpose, a scientific study in this case. And then you have the secondary use, which is when you're reusing data. So if you've collected already the health data for a particular purpose, but then you want to repurpose this, so reuse this for another purpose, which is research in this case. Now, when that secondary use is research, it is actually allowed to do so in the GDPR. Now, I'm paraphrasing a little bit here, but basically, so long as you're reusing this and this particular purpose is research, then you can go ahead and do this without, let's say, requiring extra consent from the individuals, so long as you apply the proper technical and organizational measures to make sure that you are protecting your data subjects. Now, what does this mean? What are technical and organizational measures? Well, to put it simply, it's these things, for example. So there are more that can apply, but most of the time we say, you know, if it's really sensitive data, we recommend encryption. Now, this is really something that we recommend when it's really sensitive data, because encryption can lead to issues when you forget the password. And trust me, it does happen. Then we have pseudonymization, anonymization, minimization, aggregation, abstraction, and of course, restricted access. Now, anonymization is actually very difficult to achieve if you follow the definition of the GDPR. So in most cases, we really go towards saying, towards the researchers and say, make sure that you're pseudonymizing the data and make sure that you're promising or speaking of your data as being pseudonymized. And only if you're absolutely certain, say that it is anonymized. Because if it is anonymized, then the individuals can no longer be re-identified, and in which case the GDPR does not apply at all. And that's a leap that you only want to make sure when you're entirely certain, because if you're wrong, well, then a lot of things are going to happen and not in your benefit. But to exemplify this a little bit more, this idea of further processing, does that mean basically if something was collected for research, let's say epidemiological research, and we want to reuse this data for epidemiological research, does the GDPR say that this is okay? Well, yes, it does, so long as you have the proper safeguards in place. But let's say we want to use it for a different sort of research. So we gather it for epidemiological research, we want to use it for cancer immunology, but it's still both a research. GDPR still says, okay, as long as you have the safeguards in place. But we move further along, and we can see that something is collected, for example, in hormone research. And then you want to reuse this, but not for hormone research, but for gender studies. And it's still research in gender studies. The GDPR would actually still say this is okay because it does not distinguish between types of research. It simply says, so long as the second purpose is for research purposes, then this is allowed as long as proper safeguards are in place. Now, this poses a problem for us in that we have to also look at the ethical aspects of it. So just because it would be legal, it doesn't necessarily mean it is ethical. And why I make this example is because you could see why some individuals, although they lend themselves or their data, their personal data for hormone research, they might have some issues with gender studies for whatever personal reasons they may have. And in which case, there might be some reasons as to why we shouldn't be processing this data, not from a legal standpoint, but from the ethical standpoint. And how these two meet is sometimes difficult to see. Now, we talked about further processing. You can process it. You don't need to re-ask for consent per se. But what still applies, and this is one of the rights that Prodromos introduced, is the right to information, which means that you still need to make an effort, show that you show to your data subjects that something else is happening to their data. Now, you don't need their consent for it, but they need to be informed. Unless, of course, and this is a derogation that may apply to research in some cases, is when it involves a disproportionate effort to comply to it. What does this mean? What is a disproportionate effort? Well, the way we see it is, imagine if your data set has no contact information, but the data has been heavily pseudonymized. And we think that this data, for example, poses a low risk to the individual. So we're not talking about something that if it were made public, it could cause harm to these individuals. And there is no central forum or platform where these individuals may be or have access to in which you could make this information available. In this case, we would opt for saying, perhaps here, disproportionate effort applies, and you do not need to inform all of these individuals. Now, onto the heart of it, what I want to say is when you do want to share personal data, it is possible, but you do have to think of it ahead of time. Oftentimes, researchers come to us and they have a funder mandate that says they should share data, but of course it's personal data, and they say, can we share it? What do we need to share it? Well, I usually say, let's look at the informed consent, because that's what we use as a legal basis, of course. And of course, it's also the ethical aspect of it, and see how you formulated it. Because if you've made promises that you cannot keep up, or you haven't set up your data in such a way, then it's actually no longer possible for you to share your personal data at all. Now, one of the first do's of sharing data and your informed consent is to, well, actually tell them that you intend to share this data. Transparency is key in the GDPR, right? So if you make it clear to them that this is one of the aims, you're already ahead of the curve. And just let them know that, you know, other researchers may request access for this data in the future, and make sure that they're okay with this. But also be transparent about the information that you will make available. Oftentimes, I see that researchers just say, is it okay if we make your data available? Sure, this is nice, but you want to let them know exactly which of the personal data that you've collected from them. In the case there's various variables, you're actually going to make available, which ones are actually necessary. Sometimes it is all of them, sometimes it doesn't need to be. Moreover, also let them know that you're going to protect this data in some way, so that you're going to pseudonymize it, that you're going to aggregate it. Now, here comes an issue that I want to raise up, which is how much information can you possibly fit in these things? And that's true. You don't want your informed consent to become a Bible. You still want to have some balance, because it also makes it easier to understand for your data subject. Now, a lot of this information can be layered within informed consents, which makes it easier to send this information towards your participants. But do be granular about which personal data you're collecting from them and which you plan to make available, and with which privacy measures in place. Perhaps a little bit more important, and something that I find quite often, is what you shouldn't put in informed consent if you plan or you want to share the data. Now, one of them, as I mentioned this already, is avoid terms such as fully anonymous, because it is very difficult to achieve. And to be truly anonymous, it doesn't even matter whether you can no longer identify these individuals within your own data set, but nobody else, no other organization should be able to identify these individuals. So then you can always be certain of this. And for these reasons, we always just recommend, just mention that it is pseudonymous and not anonymous. Also avoid promises to destroy all the data after they've finished with it. If you've destroyed the data, you cannot possibly share it. It's as simple as that. Now, sometimes you may have an interview in audio and then transcribe this into text, and you will delete the audio. This is fine, but make sure that you state this, and you just simply don't say all the data will be destroyed, but be granular about which data will be destroyed. Also, avoid promises that the data will only be accessed by the research team for obvious reasons. Obviously, if you're sharing the data, it will not only be accessed by the research team. If you've already made this promise, it sounds nice, but it's actually not what you plan to do. Now, when you do share data, it's important to share the metadata and place the data under restricted access. Now, this not only doesn't always need to be the case, but it does help you protect this data a lot more. Now, this can sometimes be troublesome. So for how long are you going to keep this data, and who is actually going to take care of this? And I think I have a question later on that I will address that covers this. And it's always good that if you are transferring this data, that there is a data transfer agreement in place. This makes sure that there are legal requirements that must be met by the other party requesting this data. Now, overall, the GDPR really just asks researchers to be transparent towards their participants as to how their data will be handled and for what purpose. And research does hold a privileged spot. There are derogations in place that soften some of the restrictions, so long as it is for research and so long as there are proper measures that are being adopted by the researchers. So most of all, it comes to understanding what you need. And the things that we mentioned today is, for example, understanding what is your legal basis, which one are you using? And also at which point of the data flow does this switch? Perhaps, and I think Prodromos explained this quite nicely, is sometimes you have different legal bases for different aspects of the research. And simply understanding this will go a long way. What's nice is that you can reuse this a lot of the times when you have similar research. Now, I wanted to address some of the questions that were put in, that were raised. So the first one was about what is the best way to deal with international research consortia? And can you talk about the personal data and how it will be governed within these agreements? Or do you need something else? Now, it's actually very important to put this in the consortium agreements. The problem is that a lot of the templates and the default consortium agreements do not cover personal data at all. So by the time that they're done, there's just nothing in place. Now, it doesn't need to be in the consortium agreement. It just needs to be somewhere. But definitely when you're working with other institutions, how this data is being handled needs to be sorted out. Now, it doesn't necessarily need to be standard contractual clauses. It can be simply documentation saying how it is that you're actually going to, who is the controllers, how is data going to be transferred between one institution and the other? Is there going to be a data transfer agreement in place? Or is the legal basis, if you're using consent, does this already denote that there's going to be many controllers? Again, think of these ahead of time. It's going to go a long way in facilitating the way that data can be exchanged in this consortium. And the consortium agreement is a great place to put them, but they do need to be adapted for this particular case. Now, another question was, does the GDPR apply for European Union only, or does it cover other countries? Now, this is what is called the territorial scope. Now, what needs to be understood is basically if you're a European institution, it doesn't matter whose personal data you're collecting, the GDPR will apply to you. So for example, if I collect data from Peru, from Peruvian citizens, and I am a European institution, so I'm from Utrecht University, the GDPR will apply, even though all of this data may belong to non-European citizens. And I think in that case, if you're a European institution, it will always apply. When are patient data sufficiently identified to be able to share data sets publicly online? What should be in place? What to take into account? This depends so much on the actual patient data set, right? So what variables do you have? And also depends on the legal basis and the promises that you've made to your patients. So it's a question that is difficult to answer, but like I say, what to take into account? Well, take into account the legal basis that you've had, and take into account the risks that may be posed to your patient data, to your data subjects, if this information is made public as you wish. What do you think of the privacy conditions of online meeting applications such as Zoom? They're not the greatest. So, I mean, it's definitely not, the privacy is low. But what you actually store in there, you have to be very careful when using them. How to manage publish but control access data sets for the long term. Should participants be receiving updates about how the data are being used, and who will be determining whether a third party gets access? Yes, so this is the question that I mentioned earlier. And this is something that we deal quite a lot. And it's difficult. We do say not to hand this responsibility to the PhDs, although they sometimes are often the ones who know the most about that particular data set. But because they leave, and the university should have, is at the end, the ones that are responsible for this data, they are the controllers. Now, this is not an easy question to answer, since PIs may also move, and we've also had this occur. And we've run into problems where somebody has requested access for data sets, and we had to find someone outside of the university to give access, even though we were the controllers, which should actually not be the case. If we're the controllers, we should have control over these things. So I don't have a perfect answer, but as long as you can keep that responsible person within the institution from where this data is being stored, who the controller is, that's the best way forward. But we're still moving forward, trying to figure out what is the best way to handle this. I must be honest. Ideally, when sharing data that falls under the GDPR purview, we want to have third parties sign a data sharing agreement. Can we set up standard models for such an agreement? Now, so we use data transfer agreements, and there are standard models, so to speak. We have one for the university, but we're very careful in handing these out. I've had it where people have sent me the standard model that they had for an agreement, and just simply because of the way and the nature of the processing that they were hoping, well, basically they had a certain idea of what should happen to this data, and they used a standard model. Now the standard model had a clause within it that actually prevented them from doing exactly what they wanted to do, which is they wanted to use information and link it with another set, which is fine. But because they did not understand and simply thought that a standard model would cover everything, they were about to restrict themselves from actually being able to use this data the way they wanted to. So basically the answer to this is that it's oftentimes very case dependent. And it's good to use some standard models for data transfer agreements, but you should definitely have a look at them and make sure that they are adapted to your particular purpose. Now, the last question, for data that doesn't meet the standards of what is anonymous, but would be quite difficult to identify, is there an option to control access solely by requiring the reuser to digitally sign a list of terms and conditions? So this is somewhat similar to having something that is standard that can just be signed off automatically. I don't think this is something that could be done. It's just too easy to just say yes, and then the data gets sent off. And as a controller of the data, that means that you're not really controlling who's accessing this data, but they just have to say yes thing or the other, and you haven't made sure that these people will actually hold up their end of the deal. So I think that doesn't provide enough protection to the data that you're working with. Maybe in certain situations it would apply, but that would fall outside of my understanding. That's all the questions that I wanted to answer at the moment. I know there must be more, so I'll give the floor away to the questions and answers. Thank you for your attention.
Thank you very much, Jacques, for this very useful addition, or this final part of the webinar. I'm just going to show you the link to the satisfaction survey before we go on with the Q&A, because there are quite some Q&As left in the chat window. I just have a couple of other very practical announcements, and the first one is that so I will paste the link to the satisfaction survey in the chat. The second one is that we got a couple of requests from people, I forgot to say this in my introduction actually, who were asking about local versions of this webinar in local languages, or not in English. And I just wanted to let you know that we're looking into that with the OpenAIRE NOADs. There already have been organized some webinars, if you look at our page, and on the subject in other languages. So please take a look there, and we'll try to keep you in the loop if anything, if we manage to organize other ones. And finally, just picking up on a question that was asked by a couple of people, and Jack mentioned it as well, about the use of Zoom for a webinar infrastructure. We do have, unfortunately, only limited options for using webinars of this, for hosting webinars of this size. But we can guarantee you that we will not be, so as you're not registering to the system, so we're not sharing your emails with the system. And also we are not recording the chats. So we try to be as privacy friendly as possible in a not very privacy friendly infrastructure. I just want to mention that. And now I will give the floor to Marina, who will coordinate the question and answers that are still in the list.
Okay, so thank you, Gwen. As you mentioned, there's still a number of questions that are still open. So the first one, how does the right to be forgotten work in practice for published research data? If a subject wants to be forgotten once the data is published, what are the researcher's obligations?
Do you want to say something on this one, or
Yes,
Jack?
yes, please.
Yeah, there are two things. One thing is always to remember that the right to be forgotten in relation to scientific research may be limited to the extent that such right actually prohibits the research itself. So we already have a first boundary as to how it can be exercised, which means practically if you have someone posing this question, it is again an issue of how you justify a possible denial. Having said that, if you decide to erase the data nevertheless, what you should be doing is basically make sure, first of all, that you stop disseminating from now on. And secondly, if there is something which you have shared with, and not just publicly making it available, but in different ways, then which means sharing with specific institutions, you notify them in relation to that particular data set. But if it is an open data set, I think it's almost impossible to be retracted. In that sense, if something is being released under an open license, similarly to the function of the copyright, symmetrically speaking, it's going to be impossible to retract it. So this is something that the data subject needs to know, or you need to have assessed as a risk when you make the original publication. Of course, that depends on your legal basis as well.
Thank you. We have another question specifically addressed to Prodromos. How to obtain proper legal basis for using data collected from social media in research when informed consent from individual data subject is not possible?
Okay, that's again a very good question. I think, first of all, it's probably not going to be possible, especially if you're working with any kind of large data set collection. So there you have to see whether your public interest legal basis could actually, you can get away with this, which means you have to anonymize the data as much as possible. And this as much as possible, it has to do with the purpose of your research. So if your research in itself does not allow you to pseudonymize or to anonymize, then you have to figure out a way to at least notify. So even if you don't obtain a consent, you should have some kind of notification. And this could be even in the form of a public announcement if you cannot really contact each and every individual, which is very likely you won't be able to do so. So I would suggest as a basics, the public interest one, since it's not possible for you to obtain consent. And I would say I would prefer that from the legal interest one, if I were to substantiate it adequately, which means in relation to the objectives of my research, the mission of my institution, and as this is described in statutory documents or other provisions, if it is public law provisions, if it's a public research institution.
Thank you. We also have a question related to public interest and how to prove that something is public interest, and is reuse of the data in health research, combining the research data from various studies to make data stronger, public interest by default, or some criteria has to be fulfilled?
I don't know, again, because it relates slightly, I mentioned that in the previous question, the public interest has to be substantiated specifically. So it's not a generic, like a blanket legal basis. So you need to see what is the nature of your institution and the nature of your processing in order to be able to justify that something is public interest. If you come from an institution that has a public remit, a public task remit by itself, that's a first criterion met, but it's not necessarily the only one. Then you have to go and see what is the research you're doing and to what extent can classify as public interest. And in that sense, to make your classification of public interest. Now, in relation to the combination of multiple data sets from the health sector, I think that's even more, it's even more important to justify why this, in that particular instance, it justifies the public interest. So of course, it's much easier to justify such type of research as public interest compared to other types of research. But we shouldn't just think in terms of public benefit, right? It is public interest. So it means that most of research institutions would probably be able to justify it, provided they have a consistent description and justification of what they're researching, and that's why DMP is so important.
Okay, so next question. The freedom of the arts and sciences is written in the EU Charter of Fundamental Rights, and therefore is a fundamental right guaranteed to everybody. Is performing scientific research then not in itself always a legitimate interest in the sense of Article 6 GDPR?
Jack, do you want me to take it?
I can attempt to answer this question. So, I mean, obviously, I'm not as familiar with the Charter of Fundamental Rights. I'm not a lawyer, but when I have looked into legitimate interests of the controller quite a lot, and I've tried to see how it is that it can be applied to be used for research in general. Now, something that I found when you want to apply legitimate interests, it cannot simply be that I have a legitimate interest and therefore I can use it, but you have to take into account a lot the user, and you also have to look into the data subject and think, would he expect me to be using this data for this particular purpose as well? And then from there, you have to make sure that you have good documentation as to why you believe that your interest outweighs the rights and freedoms, or the right to privacy, let's say, or let's say just say the rights of your data subjects. So there's an extra addendum to that you have to make sure that it does not get outweighed by their own rights. And I think this is where the discussion really begins. I don't know if Prodromos, you want to add to that?
Yeah, just pretty much, I'm not really in the substance. Just as I said in my presentation, I think legitimate interest is like a poisonous fruit. It seems so easy to actually use it as a legal basis, but it's not. You have to be very diligent as to how you document why you have a legitimate interest. And precisely because this balancing exercise has to be made, you require some kind of at least some legal implications assessment. You need to have, so it means quite a bit of hard work. So I'm not sure it's the best legal basis you could use.
Yeah, agreed.
If you want a fundamental right answer, which it's repeating and confirming what Jacques and Pro just said, by constant case law of the Court of Justice, none of the fundamental rights in the Charter are absolute, but all of them have to be weighted against each other. So how to weight the right to scientific research with the right of protection of personal autonomy and privacy? Well, in the way in which it has been established by the EU legislator in the GDPR. So that, the GDPR, what we're discussing is that balance. So that is how you would answer this from a fundamental right point of view.
Okay, so do you have any recommendations or guidance on how to best obtain consent for data sharing, especially if data will be shared in a repository and the intention is that the data could be reused by any interested party? How do you fully inform the data subject without overwhelming them with too much information?
Yeah, so this is an issue, right? So the way you go about actually being able to share data is by informing as much as possible everything that is planned for this particular data. And of course, you don't know what it's going to be used for, so how much can you actually say? So the idea is to just show the intent and also show what you're doing to protect them when this data becomes out there, and let them know that once this data is published, yes, it is out of your control what is going to be done with it, but hopefully the privacy measures that you've put in are enough to protect them. Now, when you're providing information, something that is allowed in the GDPR is also to layer the information. Now, when you have your informed consent form, you want to keep it concise, because this also makes it less ambiguous. But if a data subject wants to be further informed, let's say of all of their rights, for example, you can put links and provide extra information available for them should they choose to want to be informed more. And this is one of the ways that I usually, or at the university, we recommend researchers, if they have a public website or if they have somewhere, to keep some of this information, sort of a privacy notice that all data subjects can go to and will cover a lot of the rights and all of the information. So this is one way in which you can layer this information in the informed consent and not making it look, as I said, like a Bible.
And also a further question addressed to Jacques in relation to your specific certification in privacy. What certification do you have, and would you recommend it to research data support staff members helping researchers with sharing personal data?
Right, so I have a CIPPE, which means Certified Information Privacy Professional in Europe. Now, this was a certification that I obtained from the IAPP, which is just simply this organization that is for privacy professionals. I do recommend it if you're planning to delve into this a lot further. I found, from my perspective, it was necessary, because quite honestly, a lot of researchers require this kind of expertise, and it's not an expertise that is sort of new, at least in the sense that people are realizing how important it is. That being said, it does take you got to take a test for it. It's not the easiest test. It's worded for lawyers. So do take your time in studying it, and they do offer a lot of different services. I personally simply bought the textbook and then took the exam, and I just read the textbook and basically memorized it. But it's very informative, and it doesn't just apply to research. So you will be learning about other things that are well beyond what you would need from research. But it does give you a lot of confidence when you're going to be speaking to researchers about these topics. So I would recommend it, but make sure that you're willing to put the investment in it.
Yes, thank you. We also have a comment stating that some countries have specified in national legislation what legal basis for handling of personal data may apply to, for example, universities and research institutions. To make it easier. I was wondering whether maybe Thomas or Prodromos would like to say something in relation to the national legislation and what happens also in the context of collaborations in European projects.
In terms of personal rights, indeed, some legislations have provided more specific either classification of the scientific research. Normally they would put it under public interest, or they consider that as a self-standing legal basis. And I think, of course, this makes things clearer, but it's not the same across the union. Now, when we have a consortium, as mentioned during the presentation, and it was also covered partially, at least by Jack as well, you have to see who is the processor and who is the controller in each particular research scenario. Normally, we go back to the work packages and see, or the consortium agreement, and we see, first of all, who has the main, who defines the purposes and the means for the data processing, and that's the controller. If there are multiple ones, that they equally define different, let's say, stages in the life cycle of personal data processing, they're again co-controllers. If you have some organizations doing that on behalf of others, then they are processors, but this is unlikely to see in the context of a consortium. And of course, it's very different when you have the commission or a private funder or another funder to actually ask you to do to perform a specific type of research, and there you act as a processor. In all cases, you may have multiple countries and multiple entities performing the processing. That's why it is important when you do, and the Commission asks you to do that, when you do the ethics and data protection impact assessment, or at least the DMP at the beginning, to actually have a clear understanding who's processing data from the partners, under which conditions and terms, what purpose for, what are the legal basis, and how this is done in a legal and ethical manner. And again, I will repeat something that Jack said multiple times. These two things are parallel. They are successive layers. It has to be GDPR compliant. It has to be ethics committee or ethics committees compliant. And normally the Commission would ask for at least one ethics committee or at least one DPO to provide a kind of a letter or some kind of statement in relation to the legal and ethical status of the project in relation with respect to its data processing practices. Thank you.
Thank you. I think that we have answered all questions. So Gwen, any final comments?
No, not at all. Just that we are uploading the presentations to the portal and the recordings this evening or tomorrow morning. So if you want to revisit this webinar, please take a look there. And maybe also, Marina, we can mention that we will certainly have some follow-up webinars on this topic, maybe some more specific or some more example-based. Judging from the comments we're getting in the survey, which is still open, I think there's a big need for this. So we'll definitely try to follow this up. And if that's going to be the final word, I would just like to thank very much to the speakers, Thomas Margoni, Prodom's Chavez, and Jacques Flores, to take the time to present this topic twice over the last week. It's a very complicated topic, so I would really express our gratitude for them to take the time and to make sure that we have very good presentations that we will be able to share afterwards and use afterwards as well. So, and I would like to thank you as well, all of you participants, for being in such a large attendance. Everybody stay safe and healthy, and we're looking forward to seeing you into a next presentation or webinar.
Thank you very much. It was a pleasure.
Thanks very much. It's been a pleasure.
Thank you.
Thank you, everyone. Bye.